Welcome back to the deep dive.
Great to be here.
Our mission, as always, is pretty simple. We take source materials, pull out those, key insights, the crucial facts,
The aha moments.
exactly, and help you get really well informed, fast, without drowning in all the detail. We're looking for those surprising bits, essential clarity.
And today we're diving into some really foundational concepts in private international law.
Sometimes called conflict of laws, right?
That's the one. These are the ideas you absolutely need when a case, touches more than one country's laws.
And for this deep dive, our source materials come courtesy of the University of London.
Yes, and we should definitely acknowledge up front that these materials are provided for educational purposes.
Absolutely. This whole deep dive is designed specifically for educational use, nothing more.
And it's brought to you today by Sinorbit Academy, Sri Lanka.
So for all of you listening, maybe you're studying this, maybe getting ready for exams.
Good luck. Seriously, we hope this session helps clear things up and gives you a really solid footing.
So you're with us to unpack these foundational ideas together. We're talking about the basic analytical tools and, well, some really quite difficult subjects in private international law.
We'll start with characterization or classification. Same thing, really.
Okay.
Then we'll tackle the incidental question. Can get tricky.
All right.
After that, renvoi, that idea of law being sent back.
Yes, right away.
Then we'll look at when English courts might refuse to apply foreign law public policy grounds.
Including things like penal laws, revenue laws.
And other public laws, exactly. And finally, the very practical side. How do you actually prove what foreign law says in an English court?
These are, as you said, foundational, maybe a bit challenging, but really key to understanding the field.
Absolutely essential.
Yeah.
Let's jump in with that first one. Characterization
Hmm.
or classification.
So what is it, fundamentally?
At its core, it's about how a court labels the legal issue. It's the process of putting the legal question into the right legal box, the right category.
And that category then tells you which rule to use for choosing the law.
Precisely. It's the first analytical step. You allocate the issue to its correct legal category within, say, English law, if you're in an English court, and that category points you to the relevant choice of law rule.
Sounds simple enough, just putting things in boxes.
But that's where the difficulty lies. It sounds straightforward, but it's notoriously tricky. And as our sources really hammer home, getting it wrong can have massive consequences.
And the classic case that shows this is Ogden v. Ogden
Ah,
from 1908.
yes, Ogden v. Ogden.
Yeah.
Infamous, really. It's a perfect illustration of why characterization matters so much. Let's recap the facts. They're important.
Okay.
You have a 19-year-old Frenchman, domiciled in France.
Right.
He pops over to England and marries an English woman, domiciled in England.
Still with you.
Under French law specifically, Article 148 of their Civil Code, a minor like him needed parental consent to marry.
And he didn't get it.
He married in England without that consent.
Okay, so married in England, but missing this French requirement. What next?
Later on, a French court looks at this marriage. Applying French law, because he lacked consent, they annul it. Void. Kaput, as far as France is concerned.
So in France, he's not married.
Correct. The English woman, presumably thinking she's now single, goes back to England and marries another Englishman.
Right.
But then, husband number 2 petitions an English court for a decree of nullity. He argues his marriage is void because her first marriage to the Frenchman was actually still valid under English law, making her second marriage bigamous.
Wow. So the whole case turned on whether that first marriage was valid or not in the eyes of the English court.
Exactly.
Mhm.
And you see the conflict point straight away. The husband's French domicile points towards French law for things like his capacity to marry.
But the ceremony was in England.
Right. And English conflict rules say the lex loci celebrationis, the law of the place the marriage was celebrated. England governs the formal validity.
So the crunch point for the English court was how to label, how to characterize that French rule about parental consent.
Precisely. Was it a matter of essential validity specifically? His capacity to marry? Or was it just about formal validity, like rules about the ceremony itself?
And the answer completely changed the outcome for the woman involved.
Totally different worlds depending on the answer. If the English court said the French consent rule was about essential validity or capacity, then English conflict rules generally point to the law of each party's domicile for capacity. For the Frenchman, that's French law.
And French law said no consent, no capacity.
Right. So under that characterization, the first marriage would be void from the get-go.
Hmm.
If it was void, she was free to remarry, and the second marriage would be perfectly valid.
But if they characterized it differently, as formal validity,
Then the English conflict rule points to the lex loci celebrationis English law, because the marriage happened in England.
and English law didn't care about parental consent for formal validity.
Not in a way that made the marriage void, no. So if the French rule was seen as merely formal, governed by English law, then the lack of consent didn't invalidate the marriage under English law.
Hmm.
The first marriage was valid,
Which means the second marriage.
was bigamous and void.
So what did the Court of Appeal actually decide? How did they characterize it?
They characterized the French rule as formal.
Formal. Okay.
They looked at this French consent requirement through the lens of English legal categories and decided it fit into the formalities box.
And the consequence.
The direct consequence was the first marriage, because it happened in England, was deemed valid by English law. English law governed the formalities, and English law didn't require that consent for formal validity.
Even though a French court had already said it was void under French law.
Exactly. That's the paradox. So under English law, this poor woman was still married to husband number one, the Frenchman.
But under French law, she wasn't.
Correct. And this is the absolutely crucial point, something our sources stress, and something everyone studying this needs to remember. Characterization is not just some academic exercise. It's not abstract.
No, it had huge real-world impact here.
Massive. Repeat this point. Characterization is not some abstract academic game. Look at the woman in Ogden v. Ogden, effectively married to two different men in two different countries at the same time.
And the legal implications back in 1908 must have been
Oh,
dreadful.
incredibly harsh. Back then, a wife automatically took her husband's domicile. So if English law saw her as married to the Frenchman,
Her domicile became French.
exactly,
Sure.
which likely meant an English court wouldn't have jurisdiction to grant her a divorce from that first marriage. And a French court might not grant one either for a marriage celebrated in England. She could have been completely stuck.
Unable to sort out her status or legally move on.
Precisely. It's a really stark example of how characterization decisions have tangible, sometimes devastating, real-world consequences. Remember Ogden v. Ogden, a key case showing characterization problems?
Okay, that case definitely makes the point. But it also shows why it's so difficult. Where do these problems usually pop up?
Well, the sources point to three main areas where characterization gets really thorny. These are important to grasp. First, you get what are called penumbral cases.
Penumbral, like shadowy edges.
Kind of. Think of H.L.A. Hart's idea. Legal rules have a clearer core meaning, but also fuzzy edges, a penumbra. Cases that fall into these fuzzy areas, not neatly in the core of a legal category, are hard to classify.
So borderline situations that don't fit nicely.
Exactly. That's the first problem area. Second, difficulties arise when the two legal systems involved just don't agree on how to classify something.
Like in Ogden, France saw consent as essential. England saw it as formal.
Precisely. That disagreement in classification itself creates the conflict at the characterization stage.
And the third area.
This is a big one. When English courts encounter foreign legal concepts that are basically unknown in English law, things that just don't have a direct equivalent.
How do you classify something if you don't even have a similar box for it?
It's a real challenge. The sources give good examples. Things like deferred dower in Islamic law, is that a property right? Or is it like maintenance after divorce? Shonaz v. Rizwan dealt with that. Or community of property. Common in civil law systems, England uses separate property, so how do you classify that? De Nichols v. Curlier is the classic case there.
And the English trust concept causes headaches for civil law systems too, right?
Absolutely, for centuries. When you lack a familiar concept, trying to force the foreign idea into an English category can feel artificial or even impossible. So remember those three areas. Penumbral cases, disagreement between systems on classification, and unknown legal concepts.
Okay, given these difficulties, how do English courts actually do it? What's the approach?
Well, historically the main approach, and it's still very influential, is to characterize according to the Los Fori.
The law of the form. So English law if it's an English court.
Exactly. Ogden v. Ogden is the classic example. Again, the court used English ideas of formal versus essential validity to classify the French rule.
Seems logical, using your own system to understand the problem. But you mentioned critiques.
Yes, significant critiques worth remembering. The big one is that characterizing purely by the lex fori can mean the English court ends up refusing to apply a foreign rule that, if you understood it in its own context, really should apply.
Like arguably happened in Ogden, ignoring the French purpose behind the consent rule.
Potentially, yes.
Yeah.
It can disregard the foreign law's own rationale. And the flip side is also true, that you might end up applying a foreign rule in a situation where the foreign system itself wouldn't apply it, or in a way it never intended.
So you get this weird hybrid result that isn't really English law or the foreign law.
Exactly. A law that satisfies neither system. And as we said, it really struggles when there's just no English equivalent for the foreign concept. You can't easily classify the unknown using only known categories.
Okay, so if the Lex Fori approach has flaws, what's the alternative theory?
The main alternative is characterizing according to the lex causae.
The law that governs the issue itself, the foreign law.
Yes, the appropriate foreign law. The argument pushed by scholars like Wolff is that a rule's classification is part of the rule itself. It belongs to its home legal system. So if English rules point to French law, maybe French law should tell us how to classify the French rule.
Is there case support for that?
Rey Maldonado is often brought up as an example that seems to lean this way.
Right. Rey Maldonado. Let's unpack that one.
Okay, remember the facts of Rey Maldonado. You had a Spanish woman, domiciled in Spain, died intestate no will. She left movable property, like money or shares, in England.
Okay.
Critically, she had no relatives who could inherit under either Spanish or English law. So both the Spanish government and the British Crown wanted the property.
And the conflict was?
English conflict rules say succession to movables is governed by the law of the domicile Spanish law. But the Crown's claim was based on bona vacantia, ownerless goods, which is usually governed by the lex situs, the law where the property is England.
So the crucial characterization, is this a succession issue, pointing to Spanish law, or a bona vacantia issue, pointing to English law?
Exactly. Now, Spanish domestic law said that in this situation, the Spanish state takes the property as the ultimate heir. The English Court of Appeal looked at how Spanish law viewed this.
And what did they find?
They found that within the Spanish system, the state taking the property was treated as a matter of succession. So the English court characterized it according to the Spanish understanding. It was succession.
Which meant Spanish law applied.
Yes, Spanish law was the lex causae for succession, so the Spanish state got the property.
That seems sensible, understanding the rule in its own context. But this lex causae approach also has criticisms.
Yes, and the main one is a logical puzzle. Remember this critique. The lex causae approach can be circular. It seems like you need to know the applicable law, the lex causae, before you can use its classification rules to characterize the issue in the first place. But the whole point of characterization is to find the applicable law.
Right. How do you know which foreign law's classification system to use until you've already chosen that law?
Exactly. It seems to put the cart before the horse. Plus, it means the English court loses some control over its own conflict rules. And commentators like Dicey, Morris, and Collins, worried it could make decisions, hinge on just how a foreign right is worded, its verbal formulation, rather than its substance, especially concerning property in England.
So, two imperfect theoretical approaches. What do the courts actually do in practice? Are they explicit?
Not always, especially in older cases. Cases like Re Hoyles, Re Wilkes, Re Priest, Re Cohn, apt v. apt characterization was key, but the methodology wasn't always clearly spelled out. But more recent cases give better guidance.
Like Macmillan Inc. v. Bishopsgate Investment Trust Plate.
Yes, Macmillan is helpful here. Old LJ suggested the court shouldn't just look at how the parties label their claim. The court needs to identify the real issue, the substance of the dispute, based on the facts and arguments. And importantly, this identification, this characterization, is done using the concepts of the lex fori, English law.
So, back to lex fori, but maybe a more sophisticated version, not just surface labels?
Exactly. It's about the English court refining its own conflict rules. The English rule might say succession is governed by domicile, but characterization helps define what counts as succession for the purpose of that English rule. It adds precision. Remember the Macmillan v. Bishopsgate approach.
Yeah.
Identify the true issue using lex fori concepts.
Okay, let's sum up characterization. It's that crucial first step. Assign the legal problem to a category.
To find the right choice of law rule.
But it's difficult, especially with borderline cases, disagreements between systems, or totally foreign concepts.
Right, and as Ogden v. Ogden showed us so vividly, getting it wrong isn't just academic. It has real, serious consequences for people.
So English courts mainly use the lex fori approach, but it's a refined version, focusing on the true issue. Still a challenging area.
Absolutely. Fundamental, but challenging.
Okay, from characterization, let's move to another potential complication. The incidental question.
Ah, yes, the incidental question. This pops up sometimes within a larger conflict case. Let's define it carefully. Noting the conditions, repeat this definition. An incidental question arises when you're deciding the main issue, but a subsidiary issue comes up.
Okay, a side issue.
A side issue that also has a foreign element and has its own specific choice of law rule under English conflict rules.
Yeah.
And here's the kicker. Applying that rule to the side issue leads to a different result than if you just applied the law governing the main issue to everything.
Got it. Main question, side question, and the rules for each point in potentially different directions causing conflicting outcomes?
Exactly. Let's use the source as example. A Greek national domiciled in Greece dies, leaves movable property in England. Main question. Succession to that property.
English conflict rules say.
Law of the domicile. Greek law. Now, let's say under Greek law, his widow gets a share. That immediately raises a subsidiary question.
Is she actually his widow? Was the marriage valid?
Precisely. That's the subsidiary question. Marriage validity. Now, suppose they got married in England. English conflict rules for formal validity of marriage point to the lex loci celebrationis, law of the place it happened, England. Let's say under English domestic law, the marriage was valid.
Right.
But maybe under Greek domestic law, perhaps due to some religious requirement or something, it was not valid.
So main issue, succession, points to Greek law, which says widow inherits. Subsidiary issue, marriage validity, has its own rule pointing to English law, lex loci, which says marriage valid. But if the Greek succession law somehow controlled the marriage question, it might say marriage invalid.
Exactly the dilemma. The specific English rule for marriage validity, use English law, clashes with the potential outcome if the main law, Greek law, governed everything, including the marriage's validity for succession purposes. Does the English court follow its usual rule for the marriage, or does the Greek succession law somehow influence how the marriage is viewed? The widow's inheritance hangs on it. Remember those conditions. Subsidiary question, foreign element, own choice of law rule, conflicting outcomes.
And this often comes up in divorce and remarriage situations.
Yes, that seems common. The validity of a prior divorce often becomes the incidental question when looking at the validity of a later marriage.
Let's look at the cases mentioned. Schwebel v. Ungar, Canadian case.
Right. Repeat facts and outcome of Schwebel v. Ungar. Hungarian Jewish couple married in Hungary. While traveling to Israel, they get a Jewish religious divorce in Italy.
Okay.
That divorce was invalid by Hungarian law and Italian law, but it was valid under Israeli law. Later, they become domiciled in Israel. The wife then remarries in Toronto, Canada, while domiciled in Israel.
And husband number 2 challenges the second marriage, saying the first divorce wasn't valid?
Exactly.
Yeah.
He claimed bigamy. The main question for the Canadian court was the validity of that second marriage, which depended on her capacity to remarry. Capacity is usually governed by domicile at the time of marriage Israel.
And the subsidiary incidental question was the validity of that divorce.
Correct. The Canadian Supreme Court upheld the second marriage. Now, the reasoning is complex, but one interpretation is that the court decided the incidental question, the divorce validity, by looking at how Israeli law, the law governing the main issue of capacity, would view it. Since Israeli law recognized the get for its domiciliars, she had capacity under Israeli law, making the second marriage valid in Canada. Remember Schwebel v. Ungar. Maybe the law of the main issue influences the incidental one.
Interesting. So the main law sort of trumps the specific rule for the incidental point. What about the English case, Lawrence v. Lawrence?
Okay, Lawrence v. Lawrence. Repeat facts and outcome. Couple married in Brazil. Wife gets a divorce in Nevada, USA. But Brazil didn't recognize that Nevada divorce.
Right.
The very next day she remarries, also in Nevada. Later, husband number 2 asks an English court to declare the second marriage valid.
So again, main question is validity of the second marriage. Depends on her capacity to remarry, which English rules would link to her domicile, Brazil.
Correct. And the incidental question is the validity of that Nevada divorce. If it wasn't valid under Brazilian law, her domicile law for capacity, she lacked capacity.
But the English Court of Appeal
Upheld the second marriage, even though Brazilian law said she lacked capacity because it didn't recognize the divorce. The court essentially prioritized the divorce recognition aspect, finding the Nevada divorce should be recognized for the purpose of remarriage in Nevada over the strict application of Brazilian capacity rules based on domicile. Remember Lawrence v. Lawrence wrestling with this incidental question.
So clearly no single easy answer. Sometimes the main law seems to influence the incidental question. Sometimes the specific rule for the incidental question seems to win out, or maybe divorce recognition gets special treatment.
Exactly. The structure of the problem is identifiable, but the solution isn't fixed. It remains a complex knot when it arises.
Okay, speaking of complex knots, let's turn to renvoi. The word itself sounds complicated.
Ah, yes, renvoi French for sending back or return. It stems from a really basic ambiguity. Repeat this core problem of renvoi. When an English conflict rule says apply the law of country X, let's say apply French law, what does French law actually encompass?
Does it just mean the rules France applies internally? Or does it mean everything, including France's own conflict rules?
Precisely. Does French law mean only French domestic law? Or does it mean the whole of French law, which includes the rules a French court would use to decide which law applies, potentially sending the question back to English law, or even off to a third country's law?
Ah, I see the loop potential already.
Exactly. Let's use the classic example from the sources. T is a British citizen domiciled in France, dies without a will, leaves movable property in England.
Okay, English conflict rule for succession to movables.
Points to the law of the domicile at death, French law.
Right, so English rule says apply French law. Now, what does French law say?
Okay, under French domestic law, the rules for a purely French situation may be person A inherits. B duty. French conflict of laws rules might say that for succession involving foreigners, the governing law is the law of the deceased's nationality.
T was British, so French conflict rules point to.
English law.
So English rules say France. French rules say England. And let's say under English domestic law, person B inherits.
It's exactly the problem. The English court is told, apply French law. Does it stop at French domestic law, A inherits? Or does it follow the French conflict rule that points back to English law and potentially B inherits? That's the renvoi dilemma.
How do courts solve this? What are the options?
Our sources lay out three main ways this has been approached. First, the simplest, reject renvoi.
Just ignore the sending back.
Pretty much. The English court interprets French law as meaning only French domestic law. Ignore French conflict rules entirely. In our example, apply French domestic law, A inherits. Simple, avoids complexity. Some older cases, like Riansley and Riascu, noted its potential rationality.
Okay, simple enough. What's the second approach?
Second is single renvoi, sometimes called partial renvoi. Here, the English court does look at the whole of the foreign law, including its conflict rules.
So it sees the French rule pointing back to England.
Yes, it accepts the renvoi, the sending back. But, and this is the key part of single renvoi, it interprets that reference back to English law as meaning specifically English domestic law. It accepts the referral back, but only to its own internal rules.
So English rules, French whole law, French conflict rule, English domestic law.
Exactly. In our example, B would inherit. This needs proof of the foreign conflict rule, the one pointing back, but not proof of how the foreign court handles renvoi itself. This approach has support in some French cases, Forgot's case, Soulier's case, and other systems like German law. Remember the difference in single renvoi. Foreign whole law refers back to English domestic law.
Okay, so that's one level of looking at the foreign conflict system. What's the third way?
The third way is total renvoi, also called double renvoi. And this, our sources tell us, represents the current doctrine of the English courts. Repeat this key point. Total renvoi is the English approach.
Total renvoi. What does that involve?
It means the English court tries to decide the case exactly as the foreign court would decide it. So the English judge tries to put themselves in the shoes of a French judge sitting in France with the same facts.
Wow, okay. How do they do that?
They need evidence. Not just of French domestic law and French conflict rules, but crucially, evidence of how the French court itself deals with renvoi. Does the French court accept the reference back or reject it or apply its own version of renvoi?
So what are the possibilities for what the French court might do?
Well, if the evidence shows the French court would look at English law, because of nationality, and interpret that reference as meaning English domestic law, i.e. the French court rejects total renvoi or applies single renvoi in this scenario.
Then the English court applies English domestic law.
Correct. B inherits. But T, if the evidence shows the French court would look at English law, see that English law points back to France, domicile, accept that renvoi back, and then apply French domestic law.
Then the English court applies French domestic law.
Correct. A inherits. It all depends on how the evidence shows the French court would break the circle. This requires really detailed expert evidence on foreign conflict rules and foreign renvoi rules. Reed Duke of Wellington is a key case illustrating this approach. Remember the core of total renvoi. Decide as the foreign court would.
That sounds unbelievably complex to apply in court.
Oh, it is, and the sources highlight major problems with it. Repeat these difficulties. First, the massive reliance on expert evidence. You need experts who can reliably testify not just about French substantive law, but about complex French conflict rules and how French courts view renvoi itself. Getting that evidence can be incredibly difficult and costly, as Win Perry J. noted in Reed Duke of Wellington.
Finding someone who truly knows how a French judge would navigate English conflict law referring back, tricky.
Very. Second problem, potential confusion, especially with British nationality. Foreign experts might mix up British nationality with English law, just one part of UK law, leading to unclear evidence about which law the foreign court would actually apply. Re-Askew highlighted this kind of issue.
Okay, evidence problems, confusion. What's the third big critique?
It's the logical trap,
Yeah.
the inextricable circle, the circulus inextricabilis.
The infinite loop.
Exactly. If both the English court and the French court apply total renvoi, they just bounce the case back and forth forever. English court asks, what would France do? French court asks, what would England do? Which is to ask, what would France do?
Yeah.
Ad infinitum.
So it only works if the other country doesn't use total renvoi.
Pretty much. As Dicey, Morris, and Collins dryly observed, it's hardly a recommendation for a doctrine that it only functions if the other side rejects it. Remember the problem of the inextricable circle in total renvoi.
Despite all these headaches, total renvoi is the approach used in some areas of English law.
Yes, it's applied mainly in areas relating to succession and family status. Things like the formal and intrinsic validity of wills, intestate succession, legitimation by subsequent marriage, maybe formal validity capacity to marry, matrimonial property too.
Right, not everywhere.
Definitely not. Crucially, it's excluded by statute for contract and tort cases. The Private International Law Miscellaneous Provisions Act 1995 specifically rules it out there.
Okay, so quick recap on renvoi. It's about the ambiguity in foreign law, domestic, or whole system.
Right. Three approaches.
Yeah.
Reject, simplest, just foreign domestic. Single, foreign whole law, refers to English domestic. And total, English approach. Decide as the foreign court would.
In total renvoi, while aiming for harmony with the foreign court, it's complex, relies heavily on evidence, and has that potential infinite loop problem.
Exactly. A fascinating, if mind-bending concept. Remember renvoi and the English total renvoi approach.
Right. Let's shift gears now to the limits. When might an English court simply refuse to apply foreign law, even if the normal rules point to it? Starting with public policy.
Public policy acts like a safety net. It's a fundamental principle, really important to remember. An English court can and will refuse to apply a foreign law that would otherwise be applicable under its conflict rules if applying that law, or the specific result of applying it, would be contrary to fundamental English public policy. Repeat this core principle. Lord Simon, in Vervaeke v. Smith, put it clearly. If it's offensive to public policy, recognition or application will be refused.
So it's the court saying, hold on, this goes against our core values?
Essentially, yes, but it's a power used carefully, sparingly. If courts just invoked public policy whenever foreign law differed from English law, it would wreck the whole system of conflict of laws. So they're cautious, especially in cases with foreign connections.
Has the Human Rights Act changed the landscape here?
Well, there's definitely an argument, which commentators like Briggs support, that the HRA 1998 might nudge courts towards a slightly broader view of public policy, maybe being more ready to scrutinize foreign laws or judgments that clash with fundamental human rights principles.
Like discriminatory laws or perhaps certain types of divorce?
Potentially. Things like talaq, or get divorces obtained in ways that don't respect due process or equality, or foreign laws discriminating on grounds like religion or gender. We saw a strong statement in Oppenheimer v. Cattermole.
The Nazi law case.
Yes, the House of Lords refused to recognize Nazi laws stripping Jews of nationality and property, calling them a grave infringement of human rights. That shows how fundamental rights violations can trigger the public policy exception. Williams and Humbert Ltd. also touches on this.
And often, the objection isn't to the foreign law itself in the abstract, but how it plays out in the specific case.
Very often, yes. It's about the result. Think about polygamy. Even when English law strongly opposed polygamous marriage itself, the courts still recognized children from such marriages as legitimate, Bang Bose v. Daniel, or allowed wives succession rights, Coleman v. Shang, Res Sahota. Public policy considerations about fairness to the individuals involved tempered the strict non-recognition of the status itself in certain contexts.
Can public policy work the other way? To uphold something that foreign law says is invalid?
Yes, it can cut both ways. If a foreign law tries to invalidate a contract or marriage, but that law itself is seen by English courts as, say, penal or discriminatory, public policy might lead the English court to ignore the foreign invalidating law and uphold the contract or marriage. Similarly, foreign exchange controls might be disregarded if used oppressively. Re Hilbert Wag & Co., Ltd.
Where does this public policy exception tend to show up most?
It can apply anywhere, theoretically, but contracts and personal status are common areas.
Okay, contracts first. What kind of contracts might fall foul of public policy?
Even if a contract is perfectly valid under its governing foreign law, English courts might refuse to enforce it if it violates fundamental English public policy. Remember these examples, things like Champertus agreements where someone funds litigation for a cut of the winnings. Trentex Trading Corp v. Credit Suisse. Contracts unreasonably restraining trade. Agreements to trade with an enemy in wartime. Dynamit AG v. Rio Tinto Co. Or contracts deliberately designed to break the laws of a friendly foreign country. Foster v. Driscoll.
So core English legal principles can override foreign validity here.
Yes, but it's not just any difference. A foreign contract lacking consideration, required in English law, is still enforceable if valid by its own law, because lack of consideration isn't seen as fundamentally against public policy, re Bonacina. Also, under the Rome-I regulation governing contract choice of law in the EU context, the public policy exception is narrow. The foreign law must be manifestly incompatible.
What about public policy and personal status, like marriage, capacity?
Here, public policy has sometimes been used to disregard incapacities imposed by foreign law if they offend English principles. Remember these examples. Incapacities based on things like slavery, Somerset's case, religion, re Metcalfe's trusts, nationality, re Hilbert Wag & Co. Ltd., race, Oppenheimer again, certain restrictions on remarriage after divorce, Scott v. AG, physical status, re Langley's settlement, or even being declared a prodigal or spendthrift under foreign law, Worms v. de Valdor, Resellett's trusts.
So if foreign law says someone can't do something for one of those reasons, an English court might just ignore that foreign rule.
In some circumstances, yes, if the incapacity is deemed discriminatory or contrary to fundamental English ideas of liberty. It's rarer for public policy to refuse recognition of a capacity granted by foreign law, though. Courts are generally hesitant to invalidate a status validly acquired abroad, like in Cheney v. Cheney, uncle-niece marriage, or Muhammad v. Knott, marriage involving a minor, unless there's a very strong link to England and a compelling public policy reason here.
Some cases mention a residual discretion here, like Gray v. Formosa.
Yes, that idea has been floated, suggesting courts have some flexibility, but it's also been criticized for creating uncertainty compared to clearer rules.
Okay, and finally the big one, public policy and international law.
This is crucial. English public policy now clearly includes upholding established rules of international law.
And the key case is Kuwait Airways Corporation v. Iraq Airways Co.
Absolutely, the prime example. Remember the facts and outcome of Kuwait Airways. After Iraq invaded Kuwait in 1990, they seized KAC's planes. Then the Iraqi government passed a decree trying to dissolve KAC and transfer ownership of the planes to IAC, the Iraqi state airline. KAC sued IAC in England.
And the English court had to decide whether to give effect to that Iraqi decree.
Precisely. The House of Lords said, yes, we look at international law here. They found Iraq's actions, the invasion, the seizure of the decree, were flagrant violations of fundamental international law rules. Therefore, to recognize or enforce that Iraqi decree in England would be manifestly contrary to public policy.
And the really critical point was about the connection to England.
Yes, this is vital. Repeat this point about fundamental international law breach not needing an English connection. The House of Lords held that where there is such a fundamental breach of international law, the public policy exception can apply even if the case has no other connection to England. The policy being violated isn't just domestic, it's international. Here, it acted as an exception to the normal tort choice of law rules.
That's a powerful statement. So, summing up public policy, it's that safety valve used cautiously against offensive foreign laws or results, influenced by human rights, and critically includes upholding fundamental international law even without an English link, as Kuwait Airways shows.
Exactly. It allows the court to protect its fundamental principles and international obligations.
Now, closely related are the rules about not enforcing foreign penal, revenue, or other public laws.
Yes, another really fundamental principle, accepted almost everywhere. Repeat the principle. One state simply does not enforce the penal and revenue laws of another state.
And the reason behind that?
Sovereignty. As Lord Keith said in Government of India v. Taylor, Enforcing these kinds of laws would be like one state exercising its sovereign governmental power inside another state's territory. Collecting taxes, imposing penalties, these are acts of state authority. One sovereign doesn't wield its power in another's domain unless there's a treaty allowing it.
Respecting borders, essentially.
Exactly. And importantly, it's English law that decides if a foreign law counts as penal, revenue, or public. Repeat. Characterization by English law. Doesn't matter what the foreign country calls it. The English court decides based on its own understanding of these categories. Cases like USA v. Inkley and Tazarov v. Demerol confirm this.
Does this just stop the foreign government suing directly for taxes?
No, it covers both direct and indirect enforcement. Repeat that both direct and indirect enforcement are prohibited. Direct is the foreign state suing. Indirect is broader. Maybe the state seeking a related remedy, or even a private party trying to use the foreign law to achieve the state's purpose, like asserting a forfeiture. Bunko de Vizcaya case.
Okay, let's break down those categories. Penal laws first.
This isn't just about criminal law in the narrow sense. The definition from Huntington v. Atrill is the classic one. Remember the definition of penal law from Huntington v. Atrill. It covers basically any action brought by the state or a public body to impose a punishment, usually a financial penalty or fine, for a breach of public law. This includes penalties for violating revenue laws or other regulations. The Court of Appeal and AG of New Zealand v. Ortiz thought a law forfeiting illegally exported artifacts might be penal.
So, broader than just crime includes state fines and forfeitures. What about revenue laws?
Equally clear rule here. English courts won't collect foreign taxes. Goes way back. Government of India v. Taylor is the key modern authority. Tax collection is an act of sovereignty, not a private debt.
And what counts as revenue?
Remember examples of what is included. Things like income tax, capital gains tax, inheritance taxes, local rates, customs duties. Remember examples of what is not included. But not every claim by a foreign state for money is excluded. Things like recovering Social Security overpayments, Weir v. Lohr, or legal aid costs, Connor v. Connor, have been held not to be revenue laws in this sense.
Okay. And that last category, other public laws.
This is a bit fuzzier, a residual category. It's for laws that are similar in nature to penal or revenue laws, laws that enforce the foreign state's sovereign interests arising from its governmental functions. Things like nationalization decrees, maybe certain exchange controls, laws related to national security.
Any cases that help define it?
Well, AG of New Zealand v. Ortiz saw judges mention public law as well as penal. US v. Inkley, about enforcing a U.S. bail bond, had judges accepting a potential third category of foreign public law. But the best examples probably come from the spycatcher cases.
Ah, the Peter Wright book.
Remember the spycatcher cases and the concept of governmental interests? Yes. The UK government tried to stop publication in Australia and New Zealand, arguing breach of confidentiality owed by the ex-spy based on national security. The High Court of Australia accepted a principle against enforcing foreign public laws, focusing on whether the claim arose from the exercise of governmental power or asserted governmental interests. They refused the injunction because it was the UK asserting its sovereign interest in national security abroad. New Zealand courts also accepted this idea of a residual category for foreign public laws. Okay, so summing up these exclusions, English courts won't enforce foreign penal, revenue, or other similar public laws. It's about respecting sovereignty. Characterization is by English law. Penal and revenue are fairly well defined. Other public laws covers assertions of foreign governmental power, like national security interests. These rules maintain the boundaries between sovereign states.
Right. We've covered when foreign law applies, how it's interpreted, renvoi, when it might be excluded, public policy, penal revenue laws. Now, the practical bit. How do you actually prove what the foreign law is in an English court?
This is absolutely fundamental. You have to remember this core concept. In English courts, foreign law is treated as a fact. Repeat this core concept. Foreign law is a fact. It's not law that the judge is expected to know. It's a factual matter that needs to be established, just like any other fact in the case.
A fact, not law. That sounds like it has big consequences.
Huge consequences. Repeat these consequences. First, if you want to rely on it, you must plead it. You have to formally state in your court documents that you're asserting the foreign law applies and is different from English law.
Okay, plead it.
Second, and crucially, you must prove it. English judges do not take judicial notice of foreign law. They won't just look it up themselves.
And if you don't plead it or you fail to prove it?
Then the court applies English law. Repeat. If not proved, English law applies. The default assumption is that foreign law is the same as English law unless the party relying on it proves otherwise.
Hmm.
The burden is entirely on them. Remember, burden is on the party relying on foreign law.
Okay, so it's a fact, must be pleaded, must be proved, otherwise English law applies. How is it proved?
By expert evidence. That's the standard way. Glencore International v. Metro Trading confirms this.
Who counts as an expert? Just a lawyer from that country.
Not necessarily. While a judge or practicing lawyer from that country is obviously competent, the definition is wider. The Civil Evidence Act, 1972, Section 4.1, is key here. Repeat the definition of an expert from the Civil Evidence Act, 1972. It says someone is competent if they are suitably qualified on account of his knowledge or experience, irrespective of whether he has acted or is entitled to act as a practitioner there.
So knowledge or experience is enough, not just formal legal practice.
Exactly. Could be an academic who specialized in that law, Bodley Head v. Flicken. Could even be someone with practical, non-legal experience of the system, like a colonial governor testifying about local law, Cooper King v. Cooper King.
And the judge relies solely on these experts, no independent research.
The judge does not do their own research into foreign law, but they can look at foreign statutes, cases, or textbooks if the expert witness refers to them and includes them as part of their evidence. The expert presents the material. The judge can examine it.
What if the expert evidence is unchallenged? Or if experts disagree?
If it's uncontradicted, the court will usually accept it, unless it seems completely absurd or obviously wrong. If experts conflict, one expert says the French law is X, the other says it's Y, then the judge has to weigh their evidence, their reasoning, their qualifications, and decide which expert they find more persuasive.
And the burden of proof again.
Always rests on the party relying on the foreign law. If they don't provide enough convincing evidence about what that law is and how it applies, the court defaults to English law. Remember, burden is on the party relying on foreign law.
Any other side effects of treating foreign law as fact?
Yes, a couple of interesting ones. Appeals concerning foreign law points are treated as appeals on fact, not law, Barkasho v. Singh, which can affect how the appeal court reviews the decision. And, theoretically, if a conflict case went to a jury, very rare now in civil cases, the jury would decide the content of foreign law as a question of fact.
Fascinating. Okay, so to summarize proof, foreign law is a fact, must be pleaded, must be proved by expert evidence. Expertise comes from knowledge or experience, not just practice. Judge relies on the experts. If not proved, English law applies. Burden on the party relying on it.
That's the essence of it. A practical necessity given judges can't know every legal system.
We have covered a huge amount today. Characterization, incidental questions, Ranvoy, public policy exclusions, penal and revenue laws, other public laws, and finally, proving foreign law. Our source materials helpfully list some key review points or learning outcomes.
Yes, it's a good chance for you, the listener, to check your understanding. Can you explain characterization, its purpose, how English courts approach it, the main difficulties?
Can you define the incidental question, give examples, talk about the problems in solving it?
What about Ranvoy? Can you explain that core ambiguity about foreign law? Describe the three approaches reject, single, total, and explain why total Ranvoy is the English doctrine and what its problems are.
Do you grasp the role of public policy, the potential influence of the Human Rights Act, and its crucial function regarding fundamental breaches of international law, like in Kuwait Airways?
Can you explain why penal, revenue, and other public laws are excluded? What falls into those categories? Maybe citing cases like Huntington v. Trill or the spycatcher examples.
And finally, that crucial point about foreign law being a fact. What does that mean for pleading and proof? How is it proved? Who's an expert? What happens if it isn't proved?
Running through those points really helps cement the knowledge. If anything feels fuzzy, maybe loop back to that part of our discussion.
Absolutely. Getting a solid handle on these concepts, characterization, incidental questions, Ranvoy, the exclusions, proof, it's all fundamental. These are the building blocks for tackling any problem in private international law.
They show how English courts try to navigate this complex world of different legal systems, balancing fairness, respect for other countries, and upholding their own core legal principles and procedures.
So here's a final thought for you to mull over. We've seen this balancing act between applying foreign law and protecting domestic values. As the world gets ever more connected and new, maybe strange legal ideas pop up globally, how will these fundamental tools, characterization, public policy, Ranvoy, adapt? What are the really core principles guiding courts when they face completely novel international legal puzzles? Something to ponder. We really hope this deep dive has been helpful for your understanding and preparation.
And once more, our sincere thanks to the University of London for making their excellent educational materials available.
And thank you for joining us for this exploration brought to you by Sinorbit Academy, Sri Lanka.
For everyone facing exams, you've got this. Keep pushing. Best of luck.
Stay curious.
See you on the next Deep Dive.